Criminal law relates to the types of behaviour which is deemed unacceptable by society. This regulation takes the form of offences and crimes created to check and protect society as a whole, as well as individuals' interests and certain property rights. Essentially, criminal law represents society's interpretation of the difference between right and wrong. It is for this reason that a crime is seen as a public wrong and a need to protect the moral fabric of society. The law, in the form of common law and statute, has developed over many years. It is not the job of the criminal justice system to enforce public morals. Morality may inform the legislator when deciding whether the conduct of the individual inflicts substantial harm and therefore should be subject to criminal sanctions. However, the general view of what constitutes immoral behaviour may not always reflect what is not a criminal offence. For example, people might view adultery as immoral, even totally wrong. Nevertheless, embarking on such an affair, however scandalous, it is not a crime. In addition, changes in our society or attitudes can also result in accompanying change in the law. For example, marital rape was finally recognised as a crime in 1991. Homosexuality has now been decriminalised, although this was not until 1967. One minute certain drugs are deemed to be illegal, the next they are declassified. New technology brings with it new challenges, possible infringes, and therefore new law. This certainly is a vibrant area of the law. The needs of society need to be protected against prohibited behaviour. This must be carefully balanced with the requirement not to infringe basic rights, bearing in mind human rights of the defendant. Therefore, following an allegation that has been made that there has been a breach of the law, the defendant will be considered innocent until proven guilty. He will be entitled to a fair trial, and the burden of proving the case against him lies solely with the prosecution. As a matter of analysis, we can think of a crime as being made up of three ingredients: actus reus, mens rea, and a negative element, in brackets, the absence of a valid defence. Now I'll go on in turn to explain that quote now. First of all, we'll look at actus reus. This phrase usually refers to the actions of the defendant which is prohibited by law. This is the essential element of the offence to assist in determining the relevant rules. Offences can be categorised in a number of different ways, although it should be noted that most crimes can fit into more than one category. The conduct offences, in some cases, the offences will only require certain acts to be committed by the defendant to satisfy the actus reus. For example, fraud by false representation under the Fraud Act of 2006, Section 2, requires simply that the defendant makes an untrue or misleading representation. There need not be any harmful consequences from this action. Looking at the result of the offences, the actus reus of the result crimes requires more than just the defendant's actions. Here the action must lead to a specified consequences.